If you do send this 14-day notice and they correct the problem, whether it be by rent or by other condition that is there, then if they do it again within 6 months, you can reduce that 14-day notification to a 7-day notification. And you can proceed, you can move a little bit faster. So that if they haven't complied with the second letter, then in 7 days the lease terminates. So you wouldn't just change that 14 days to a 7-day notification. And you have to set out what the problems are in this notification letter. If you'll look in the form that I gave you, the first full paragraph, it says, please take notice. And referencing the lease agreement, referencing the premises, it says how much rent you're behind. Well, if you already have just a waiver of rent, you don't need to put that in there. You can leave that blank. But if there's a material compliance issue and you don't have the waiver in your lease, then you're going to spell out in that third paragraph just exactly what the problems are. Now, if there are repairs that have to be made, the tenant can't make the repairs unless the landlord approves those repairs, authorizes those repairs. This letter tells that to the tenant. That's required. And that's in the form, and it's in bold in this form that I've given you. But the tenant has to get permission from the landlord for those repairs to be approved to be done by the tenant or someone that they've employed. Gives the landlord the opportunity to determine who's doing those repairs and whether they will be adequate and correct the problem. So you want to have that as part of your armor, so to speak, in dealing with the tenants on non-compliance. Let me move on here to. We got several pages here. We got 14 days. All right, critical point here. You're in the midst of a tenant who is not paying you rent, and you want to evict them. You even have a waiver of notice in your lease, or you've given them the 14-day notice, and the 14 days has expired, and you're wanting to start, and you're getting ready to start an eviction, and they come running up to you and say, "Listen, here's $500, I'll pay the other $200 in a week." And your problem is, gosh, I need that money to pay the mortgage on this house. Or man, I got another bill, I could use that money. Okay, all right, I'll do that, I'll agree with that. You don't reserve your rights to continue. You just blew your eviction. You have condoned the conduct of the tenant, and you have waived your rights to continue with that eviction process. So whenever you receive money, whether it is brought to you personally or they mail it to you in the mail, send you a money order, you need to immediately, on a receipt for the cash, you need to write "accepted with reservation of rights." That is a key term that you need on your receipts. If they mail it to you, you do not hesitate. You have a form letter that says, "I have received X amount of dollars in the form of whatever it is, check, money order, or cashier's check. But we are receive this under a reservation of rights under the terms of our lease." That gives you the right to continue with eviction. And you make sure you keep a copy of that, because that could be asked for in court. When you go to court, the tenant says, "Well, I paid him, he accepted the money." "Yes, Your Honor, but we sent out a notice, or our receipt shows that we accepted with reservation of rights," and the tenant's done in that issue. Yes? Hey, Mike.
Is this when you accept the money after you file?
At any time after the breach, and you've started the process, you tell them, "I'm going to start an eviction." It could be before you file, and you went on ahead and filed, but you accepted the money in between, and you didn't retain your reservation of rights. You didn't give him that. You've just kissed your lawsuit goodbye. Okay? If you do it after they file the lawsuit, after you file the lawsuit, same situation. Your lawsuit's gone for that particular breach now. Not forever, but that particular breach.
So if they pay part of it, you can't file a suit for
Are you,
the remainder of it?
if you accept it with reservation of rights, yes, you can. You can keep going. You just give them credit for what they paid, but say, oh, well, you still owe me $200, and by that time another month's come up, well, you owe me that, plus I've incurred court costs, and you got to pay all of this. So, but you need, that's a critical issue about what you want to have when you're dealing with the tenant that's in default.
Bucky,
Yes.
real quick, I have my stamp when I collect any money from someone, any check, it has the company signature that says accepted with rights of reservation on the stamp. Any branch or anything collect from anyone, anything.
That's all you need to have. You need to have something that's just quick, pop, give it to them. If they come and give it to you, put it on a receipt, put that stamp on there. Make sure you retain a copy of that. So you've got that as a record. Just don't give the tenant the original. Oh, he never gave me he never gave it that to me. So you make sure you retain a copy of it going forward. So again, utilities, we covered this. If the utilities are in the landlord's name, you can provide in your lease that the tenant has to convert them over to their name, and you can require them to do it in 3 days. If they don't, you can turn the utilities off. You can also say for their failure, you can evict them. Because I think Jim Gosney was talking about, if they're not going to pay their utilities or get them turned over to you, they're trying to stick you, you're going to have a problem with them going forward. Violence or threats in landlord termination. This statute 6628-517 gives the landlord the right to terminate a rental agreement within 3 days from the date notice is delivered to the tenant or any other person on the premises with the tenant's consent that willfully or intentionally commits a violent act or behaves in a manner which constitutes or threatens to be real or present danger to the health, safety, welfare of life, property, or other tenants. Now, that's kind of a broad statement, but if somebody comes over and they get into an argument with somebody that's come over and somebody pulls a gun and gunshots are fired and somebody gets injured, that's a violent act. You want to give somebody, you don't want that happening in your property. This statute also could tie in, honestly, to there's a criminal statute that the Attorney General enforces. Let me find that back here. It's 667107. It's criminal activity. If any kind of criminal activity that results in a charge of a felony for drugs or prostitution, or the landlord is suspicious that that kind of activity is going on, you can contact Crime Stoppers or the Organized Crime Unit. They'll make an investigation. If they make that determination, actually the Attorney General becomes involved, they will send a letter that will terminate the tenant and tell them to vacate the property. Now, they give them 30 days notice to do that. Typically, I talk to the Attorney General. They don't normally take that long once they send out that notice for the tenant gets out. But that's something to back you up, because under 6628-517, this statute, look at the bottom one. If the landlord's action in terminating the lease in this provision is willful and not in good faith, the tenant may, in addition to recovering actual damages sustained by the tenant, recover reasonable attorney fees. So if you're going to proceed, particularly because of some acts here, one, you want to make sure you have the incident reports and giving that notice and pursuing this action under this statute. Or kind of fall back on the AG's office, get them to make an investigation. If it's just domestic violence that's not a felony, then they're not going to get involved. According to the AG I talked to, she says every morning she reviews the charges and arrests of people who come in, and if there's drugs or prostitution involved, they check out the address. If it's not the property owner who owns that property, and it turns out it's a tenant, they're going to look for the landlord. They're going to send a notice to the tenant, and they're going to contact the landlord. And they can begin and do evictions and charge you, and that may be your savings grace, that you let the AG's office file it. It's worth paying them the cost, because you're going to incur the cost on an eviction anyway, but then it's the AG's who is out there in the front, and you're kind of, just get them out of my property so I can get back in and do what I need to do to get it re-rented. Because if these people are drug dealers or in prostitution, they may have some Guidos that you don't want to run into, okay?